Good morning, everyone, and can I welcome you to the public meeting of the 27th meeting actually in 2020 of the Social Security Committee. We've got apologies this morning from Alison Johnson and Mark Griffin, who unfortunately can't be with us. Before we actually move to agenda item 2, can I just note that agenda item 1 was in private, which was a briefing on Brexit and devolved social security. I can put on public record my thanks to Dr. Simon Roberts, who took us through that presentation this morning. That was most welcome. And we now move to agenda item 2, which is decision to take another item in private. The committee is asked to agree that item 10, work programme discussions, and item 11, consideration of an issues paper, are taken in private. We're going to assume everyone agrees unless there's an indication in the chat box otherwise. There have been no indication. We'll now move to agenda item 3, subordinate legislation evidence. The committee will take evidence on 2 connected affirmative instruments, and these are the Carers Allowance Supplement and Young Carers Grants Residence Requirements and Procedural Provisions EU Brexit Scotland Regulations 2020, and the First Tier Tribunal for Scotland Social Security Chamber and Upper Tribunal for Scotland Allocation of Functions, Procedure and Composition Miscellaneous Amendments Regulations 2020. I think you could probably suspect why we had that briefing earlier on about EU implications for Brexit and social security. Can I welcome Shirley-Anne Somerville, Cabinet Secretary for Social Security and Older People, in supporting us in our evidence session today, and her accompanying officials, Jane Sterry, Carers Benefits Policy Unit, Rebecca Hack, Cross-Cutting Policy Team Leader, and Susan Robb, Solicitor. Can I invite the Cabinet Secretary to make an opening statement, and then we'll move to some questions.
Thank you, Convener. Good morning. Carers Allowance Supplement and Young Carers Grant are both completely new forms of support we have introduced to improve financial assistance for carers in recognition of the vital role they play. In discussion with the UK Government and the EU Administrative Commission on Social Security Coordination, it was these benefits were in scope of EU rules on social security coordination. This means they should be available to carers living outside of the UK in the EEA or Switzerland in certain circumstances. The Carers Allowance Supplement and Young Carers Grants Residence Requirements and Procedural Provisions Regulations before you today have been brought forward to expand the residency criteria for these benefits. We expect the number of carers affected to be small, but the regulations will make sure that all eligible carers are able to get the support they're entitled to. And this will include past payments going back to the launches of the 2 forms of support. The approach in the regulations will allow carers to apply for and receive Carers Allowance Supplement or Young Carers Grant where they are resident outside the UK in the EEA or Switzerland, where the UK remains the competent state for payments of cash sickness benefits to them, and where they can demonstrate a genuine and sufficient link to Scotland. The genuine and sufficient link test was chosen as an approach that has been tried and tested legally and found to be compatible with EU law. As we approach the end of the EU exit transition period, it should be noted that the provisions in these regulations are likely to apply only to those in the protective cohort set out in the EU withdrawal agreement and similar agreements, that is, in the main, those who are already in a cross-border situation by the 31st of December 2020. The Scottish Government's view is that Scotland's best interests are served by remaining a member of the EU with all the advantages membership offers. It is unfortunate that we do not have more clarity on what the social security coordination arrangements will be at the end of this year. I would also like to note my gratitude to Dr Sally Witcher and the members of the Scottish Commission on Social Security for their consideration of these regulations in a much reduced timescale to support us to bring these to Parliament ahead of the end of the EU exit transition period. If passed, the regulations will come into force shortly afterwards, and Social Security Scotland will be ready to take applications from eligible carers outside the UK. We will also be working with our stakeholders and networks to get the message out to carers about the changes early in the new year. The First Tier Tribunal for Scotland Social Security Chamber and Upper Tribunal for Scotland Miscellaneous Amendment Regulations we are also considering are needed to give full effect to the Carers Allowance Supplement and Young Carers Grant regulations. They expand the functions of the Social Security Chamber of the First Tier Tribunal for Scotland to include dealing with appeals from outside the UK relating to Carers Allowance Supplement. We also ensure relevant provisions which apply to appeals relating to other forms of devolved assistance also apply to carers allowance supplement appeals from outside the UK. I appreciate this opportunity to assist the committee in their consideration of the regulations, and I'm happy to take questions, Convener.
Thank you very much, Cabinet Secretary. I've had one indication so far for a question in relation to this agenda item. If other members want a question, can you put an R in the chat box? And can I go to Shona Robinson, MSP?
Yeah, good morning. It was just really to ask at this stage whether the Scottish Government has a view on what the entitlement to devolved benefits should be for those not protected by the withdrawal agreement, or is that too early to say at this stage?
Well, we are in the unfortunate position, as the committee knows, that we do not know what will be happening at the end of the transition period at this point. The current negotiation positions on this issue between the UK and the EU are quite far apart, and we don't know what will happen during the negotiations if an agreement will be reached on this, and indeed, of course, on the other issues. That leaves us quite in the dark about what will happen after the 31st of December. Obviously, as I said in my opening remarks, it would be the Scottish Government's preference for us to be a full member of the EU and to have that coordination over social security at an EU level. Unfortunately, given the restrictions that the Scottish Parliament has, it's not within the gift of the Scottish Government to be able to make our own arrangements on that, and that will have to be done at a UK level, which is of course exceptionally disappointing.
Thank you.
Thank you, Shona. And Polly McNeill.
Thank you, Convener. Good morning, Cabinet Secretary. Yes, we did have a session in private this morning, so to get some understanding of the coordination rules, and it's quite complex. But one of the things I picked up was that within the withdrawal agreement, that domestic courts can refer cases where there's a question mark or a challenge over the application of any benefits, including those benefits which are Scottish defined, for a period of 8 years. So it's not clear what happens after the 8 years. But my question to you is, what would you, as a Scottish Government Minister, be expecting of our domestic courts? I mean, I suppose I'm expecting you to say that you would expect the domestic courts to apply the general principles as they are now, and not depart from what people have, enjoyed benefits, including the new benefits. So those obviously up to 31st of December have a certain level of protection, and those after the 31st of December, that's not clear. But I suppose I was just trying to get to put on the record, what would your expectation be of the Scottish courts in applying the coordination rules? Thank you.
So we may be in a position where we have to bring further regulations back to the Scottish Parliament if there are changes in what is expected over social security coordination because of, for example, an agreement on this either at a bilateral level or at an EU level, and that may happen in due course. The aspect around what we would expect the Scottish courts to do is of course, as a member would expect, is to follow they will put in place and rule on the regulations as they stand at the moment. And it's the responsibility of the Scottish Government to ensure that we will continue to keep those regulations as updated as required, given if there are any further arrangements made at a UK level, as I say, either bilaterally or with the EU as a whole. So we'll keep the regulations updated, and the courts will fulfil their requirements to rule on whatever regulations are in place at that time.
Thank you. Just a brief follow-up. So, the purpose of regulations might be that, I suppose, any Scottish court could rely on the regulations and not have to refer to the ECJ, because the regulations would set out the requirements of benefits to be applied for those in the EU. countries, member states. Is that the?
I mean, apologies. I mean, this is something which we're keen to ensure that we're working very closely on, because it's something which is a developing situation. So policy officials are working very closely with Social Security Scotland to develop processes and coordinate any changes required to internal and external procedures and guidance as the result of emerging case law. So we'll do everything that we can internally to ensure that we are moving ahead if there is emerging case law that we need to take account of. We have a responsibility from a Scottish Government perspective to ensure that we continue to remain up to date with any requirements we have to change regulations about coordination in general.
Perhaps you could get back to the committee at a later date, but I just suppose I was wanting you to say that the regulations would be, you would expect Scottish courts to implement the regulations, because I could see quite long delays, I suppose, if Scottish courts felt they had to bear cases to the ECJ. But I mean, obviously that's a limited period, but if that was possible, that would.
It's possible. I'm missing part of Ms McNeill's questions as well, because I thought I'd answered it, but yeah, I'm certainly, I don't know whether it's my connection.
To be honest, not really, because what I was hoping that you would say is that the regulations, are they going to clarify how, I was hoping that you'd say that these regulations would help Scottish courts clarify what's expected of them, because otherwise, and I have a very limited understanding of this, I have to say, you'd have to defer everything to the ECG, which we wouldn't want. So the court, yeah.
Yeah, so, well, certainly I think these regulations and the purpose why we made some of the changes to the regulations during the drafting procedures was to give as much certainty as we can with the current cohort, the protected cohort of EU citizens, and as much certainty as we can about how they will be provided. And absolutely, the courts will take those forward if any cases come before them. So this is very much an attempt to create as much certainty as possible in a very uncertain situation.
Thank you very much.
Thanks, Pauline. Rachel Hamilton.
Hi, morning, Cabinet Secretary. I want to kick off. My first question is, what is the definition of a genuine sufficient link to Scotland, so that people that are concerned about this are clear about that they actually qualify for this process?
So the information will be available for potential clients on mygov.scot on what is meant by genuine and sufficient link. That will be guidance that's also obviously available for client advisors within Social Security Scotland. It's important to note, I suppose, that the application of this test really does need to be flexible, which is why it's not in regulations but in guidance. It needs to take account of a range of factors that someone can demonstrate a genuine and sufficient link in line with EU rules, and that's the reason why it's not there within the regulations themselves. Some of the examples around that can be, for example, periods where a person has been living, working in Scotland, and situations such as those. But I think the challenge, if it was in regulations, would be to have a definitive list, and that we wouldn't accidentally miss someone off that list if it's in regulations. So it is designed to be as flexible as we can to ensure that we capture as many people as required. But I hope some of the examples there that I've given to Rachel Hamilton helps in that situation.
Yeah, I mean, I just want to confirm what you're saying. That does that mean that if it's not defined specifically, there is, in the word that you use was flexibility, there is discretion for whomever is dealing with that particular case?
Well, the client advisors will refer to the guidance that will be available through the Social Security Scotland internal guidance procedures. So that's to ensure that we will capture as many different ways where a person can have genuine and sufficient link. Now, that may involve limited discretion to the client advisors, but it will be, I think, very limited because the purpose of the guidance will be to try and give examples of that, either concrete examples, for example, working or staying in Scotland, or give the types of areas where a client advisor may wish to make a decision on this.
My next question is, how have you estimated the number of people who will be affected by this? Because our brief suggests that it's quite low, and if I'm right in saying it's something like between 20 and 120. How have you come to that conclusion?
So what we can use for carers allowance supplement is an estimation using DWP figures about how many people receive carers allowance out with the UK that may have attachment to Scotland. There's not a similar procedure that we can do with Young Carers Grant because there's not a comparator within the current DWP system. So that makes forecasting those numbers exceptionally problematic. But I think what is clear is that it's a very small number, both for a carers allowance supplement and for the Young Carers Grant. And the numbers that you've suggested are the numbers which we are estimating for carers allowance supplement. But as I hope the committee will appreciate, it is very, very difficult to have a firm forecast on that in any manner of means.
So my last point on this is that people will need to apply, because if they don't apply, they will have no right to appeal. So therefore, what is being done between Social Security Scotland and DWP to source these people, or is that impossible? Do you have to go about it in a different way?
So it is very difficult to be able to ensure that.
Okay, you're back.
It is very difficult to ensure that we can encourage people to take up their entitlement in this area. We are continuing to liaise with the DWP to see what can be done on this issue, and we're also working, for example, with carers organisations here in Scotland so that we can see whether we can use their links with other carers organisations, for example, to be able to highlight this to as many people as possible. So we've already been doing that work with stakeholders, to find the relevant organisations that we might want to link with and relevant networks in Europe. And obviously, if the regulations are passed by committee, then that's something then that we can move forward with. But it is a very, very challenging area, particularly because it's such a small cohort of people. But we're determined to do what we can in this situation to work with stakeholders to see if we can ensure that we're raising the entitlement to this as much as possible.
Thank you. Convener, will somebody else be asking about the exportability of the other devolved
I answer that question, I'm afraid, Rachel. If you want to ask another question, you can do.
Well, it's just that our presentation before suggested that some of the issues would be discussed at the Administration Commission. I think that's what Administrative Commission. And I just wondered if you or the Scottish Government had thought that they might legislate prior to any discussion that goes to the Administrative Commission in order to ensure that that there was reassurance for people who were in this circumstance that were perhaps applying for disability benefits.
So the decisions around this, as you quite rightly point out, are decisions for the EU Administrative Commission on Social Security, not one that the Scottish Government can take. But because the benefits that we are devolving, with the exception of the ones we've looked at today, have a DWP equivalent, it's easier to forecast what that Commission's determination might be. So, for example, we would expect the care components of the devolved disability assistance, winter heating assistance, Scottish carers assistance to be exportable in the same way that the existing benefits will replace. So we'll be drafting legislation on that basis for those benefits. So we have an easier read across when it comes to the disability benefits that are now being devolved and the carers benefit, to be able to, in many ways, assume that the same decision will apply as is already applying for the existing benefits that are in place, and we'll work accordingly to ensure that people don't lose out as we transfer over to the new Scottish benefit.
And just to confirm that does include your consideration of the new benefits, such as the Best Start payment. I mean, I know this is very small numbers here because that's such a new thing, but I presume that consideration would take that into account too.
So there are a number of benefits which we already have, and Best Start grant being one of the examples of that, that are not exportable. So the forms of assistance currently delivered, like Best Start grants, Best Start feuds, funeral support payment, job start payment, are not exportable. That is our view. It's a view shared by the DWP and HMRC. It was due to be presented to the Administrative Commission in March of this year, but the COVID outbreak delayed that, and as such the benefits are still being considered. So that's where it stands at the moment, but it certainly is the view of the Scottish Government and the DWP that they will not be exportable.
Thank you.
Okay. Thanks, Rachel. Just before we move to the next agenda item, Cabinet Secretary, you can tell we've literally just had a briefing on this before you came to committee, hence the questions. But it would be good to get some clarity around, because as we get it, that Best Start grant, Best Start foods, and you put out the government position there, and those 4 new forms of social security assistance, the European body will have to decide whether to determine these to be social security payments, social assistance payments, or there's kind of halfway house in relation to that. Will the Scottish Government be able to make direct representation to that European body? Would you have been able to do that in March this year, or would that have been done through the UK Government, or would it have been done in partnership? And what's that likely to look like in the new year when Europe decides the designation, if you like, of these new Scottish benefits, or the categorisation, I suppose, to be more accurate?
Yeah, so the future decisions of the Administrative Commission will still continue to be important, not just for those benefits that we've just talked about, but for all decisions that might affect the protected cohort. So we will still continue to engage with the EU relevant institutions, but that will be through the UK's representation at joint UK-EU committees, as those things are decided on a UK-wide level, and not something that Scotland can come to a differing opinion on to the UK.
Okay. There being no other questions, we'll move to the next agenda item, Cabinet Secretary. I think you can see a thirst for the committee to better understand this developing area of social security policy. And we now move to agenda item 2, and can invite Ms Somerville to move the motion S5M 23567, and that is Social Security Committee recommends that the Carers Allowance Supplement and Young Carers Grants residence requirements and procedural provisions EU Exit Scotland Regulations 2020 be approved. Could you move that, please, Cabinet Secretary?
Moved, Convener.
Now, I'm hoping there will now not be a debate on this matter, but there's provisions. Are there any comments members would like to make at this point? I think we had a good cut at it in the last agenda item. Okay, thank you. There being no comments that members wish to make, I'm assuming that the Cabinet Secretary doesn't have any final comments to make in summing up and would still wish to have the motion pressed here this morning.
Yes, thanks, Convener.
Okay, thank you. So is the committee content to recommend approval of this instrument? Again, unless I see something in the chat box, I'll assume that is the case. Okay, we are content. We now move to agenda item 5 and can invite Ms Somerville to move the motion S5M 23353, and that motion being Social Security Committee recommends that the First Tier Tribunal for Scotland Social Security Chamber and Upper Tribunal for Scotland allocations of functions, procedures and composition miscellaneous amendments regulations 2020 draft be approved. Can I ask you to move that motion now?
Moved.
Thank you very much. Does any member wish to take part in the debate in relation to this particular motion? Cabinet Secretary, I'm assuming you wish to press this particular motion?
Yes, Convener.
Yeah, okay. Is the committee content to recommend approval of this instrument once more? If I don't see anything in the chat box, I'll assume that we are content. Okay, there'll be nothing in the chat box. We are content. And we now move to agenda item 6, European Union Withdrawal Act 2018 consideration of procedure. I refer members to page 5, the Social Security Coordination EU Exit Scotland Amendments etc. Regulations 2020 SSI 2020/399 are made using powers under the EU Withdrawal Act 2018. Under the protocol between the Scottish Parliament and the Scottish Government, the committee is required to consider whether the procedure attached to the SSI is appropriate or should be changed. The instrument is subject to the negative procedure, and Scottish ministers have categorised this instrument as a low significance as the amendments are minor and technical. The DPLR committee considered the instruments at its meeting on the 15th of December and agreed that the negative procedure was appropriate. Is the committee content that the negative procedure is appropriate for this instrument? Again, I'll take silence in the chat box, so to speak, as the committee being content. That being the case, the committee is content, and we now move to agenda item 7, subordinate legislation consideration of instrument, and can refer members to papers 6 and 7 for consideration of Social Security Coordination EU Exit Scotland Amendments etc. Regulations 2020 SSI 2020/399. As noted at the previous agenda item, this instrument is subject to the negative procedure. The instrument has two main purposes. It repeals the EU regulations on social security coordination, that being the EU regulations, insofar as relating to devolved social security matters with effect from the end of the transition period. It amends 3 Scottish statutory instruments to remove reference to EU legislation and makes provision to ensure continued access to the specified benefits for those persons protected under the withdrawal agreement. Are members content to note this instrument? No comments in the chat box. I'll assume that means members are indeed content. And we now move to agenda item 8, evidence on subordinate legislation. The committee will now take evidence on the Scottish Child Payment Amendment Regulations 2021 and can refer members to papers 9 and 10. Can I welcome Shirley Ann Somerville, Cabinet Secretary for Social Security and Older People, and accompanying officials. Don Abel, Head of Scottish Child Payment and Reserve Benefits Team, Rebecca Darge, Scottish Child Payment Policy Lead, and Stephanie Verlageau, Solicitor. Can I invite the Cabinet Secretary to make an opening statement and then we'll move to questions.
Thank you, Convener. The committee's scrutiny throughout the development of the Scottish Child Payment for Under 60s, which, as you know, has happened at an unprecedented, is greatly appreciated. The Scottish Fiscal Commission has forecast that up to 194,000 children could be eligible this financial year, showing the real impact that this payment can have. Today, the committee are being asked to recommend for approval the Scottish Child Payment Amendment Regulations. Scottish Child Payment is provided for under Section 79 of the Social Security Scotland Act 2018, which enables the top-up of reserve benefits, the quickest route for us to tackle child poverty. And the Scottish Child Payment Regulations, which were recommended for approval by this committee on the 24th September, set out the rules and eligibility criteria for children under 6. These amendment regulations make minor technical amendments to the principal regulations to ensure that the Scottish Child Payment eligibility is aligned with our original policy intent on nil awards. It also ensures that the processes for making payments of Scottish Child Payment to clients claiming for additional children, where the client is already in receipt of Scottish Child Payment for another child, is as straightforward as possible. On nil awards, the Scottish Government is opposed to the punitive sanctions imposed by the UK Government, recognising the risk this poses of pushing people into deeper poverty. In circumstances where our clients receive a nil award as a result of sanctions, we will continue to pay the Scottish Child Payment. The amendment regulations also set out that we would expect eligibility to continue in circumstances where an award is reduced to zero as a result of deductions for liabilities, for example due to gas and electricity arrears. This approach ensures consistency with our other Scottish low-income benefits, such as the Best Start grant, and supports families facing a significant reduction in their income. The principal Scottish Child Payment Regulations set out that a client is not required to complete a new application for additional children if they have ongoing entitlement for another child. These amendment regulations make things more straightforward for clients in this scenario, enabling the date of payment for additional children to be aligned with the client's existing payment cycle. This is based on feedback from clients who have told us that they value both predictability and certainty in relation to payments, as it helps with the management of household finances. Finally, I want to put on record my thanks again to the Scottish Commission on Social Security for their scrutiny of the draft amendment regulations to expedited timescales and for their continued support throughout the development of the payment. The Commission published their scrutiny report on the 20th of November, and I'm pleased to advise that we have accepted or partially accepted all of their recommendations. I hope that you can recommend these amending regulations for approval today to enable them to come into force ahead of eligibility for Scottish Child Payments introduction in February, with first payments to follow soon after. I'm happy to take questions.
Thank you very much, Cabinet Secretary. At the moment, I don't see any bids for questions. I'll just give a few seconds in the chat box before we move to the next agenda item. Okay, there have been no bids for questions. We will move to agenda item 9 and can invite Ms Somerville to move the motion S5M 23673 that the Scottish Social Security Committee recommends that the Scottish Child Payment Amendment Regulation 2021 draft be approved. Could you move that, Cabinet Secretary?
Moved, Convener.
An opportunity for a contribution from members at this point if they wish. I'm just noting the chat box if anyone wants to come in at this point. Okay, in which case can I ask the committee whether they are content to recommend approval of this instrument? Once more, I'll just monitor the chat box. There will be no objection in the chat box. The committee is content. Can I thank the Cabinet Secretary and her officials and formally close the public part of this meeting? So thanks everyone, and as previously agreed, the committee will now move into private session for the remaining agenda items. So members should unload on the other platform, Blue Jeans, and we'll move in, other platform, MS Teams, and come off of this platform, and we now move into private session. Thank you everyone.